We are back on the record at 11:51.
Are you ready to proceed?
Yes, ma'am.
Okay, great. Do you still have Exhibit 1 in front of you?
Exhibit 1. This was this letter. Yes, ma'am.
Okay. The letter from Mr. De La Fuente, January 25, 2019. Are we together on this?
Yes, ma'am.
Okay, good. Just want to cover a couple things. You'll see in the first page of that letter and the second paragraph, it talks about 3.86 acres along the west side of Piper Lane in Spicewoods, Texas. Do you see that? Mm-hmm. And a right of refusal to purchase an additional approximately 7.01 acres. Do you see that?
Yes, ma'am.
And it says the total price paid for these interests was $203,000. Do you see that?
Yes, ma'am.
Did you ever learn anything to suggest to you that those facts were not accurate?
Check the form.
I'm sorry. Say your question one more time. Did
Sure.
I ever?
Did you ever learn facts that suggested to you that what had been recited here in this letter as factual information was not accurate?
Check the form.
Check form.
Did I ever learn? I can't recall. I read the original contract, but I can't recall the details as to whether it said 4.3 or something else. But I can't, I mean, my recollection of reading that contract is foggy on that matter.
Okay.
So that would be a response to your question, because there was, at some point, 4.3 has come into the mix. Now, where I learned about that, I don't know. I mean, I can't remember if it was reading the contract or something else. But I think that hopefully I'm responding to your question.
But when the lawyer says in the letter that what was conveyed was 3.86 acres and a right of refusal, and that the total price paid for both interests was $203,000. So far as you know, that's accurate information, correct?
Check the form.
Check form.
Well, no. I mean, if I've heard from somewhere else and looked at the contract that it was 4.3, then I would look at that and say, well, what about the other half acre?
Okay, so you've undertaken to investigate what it appears was contracted for back in 2016. Is that right?
At some point, yes.
When did you do that?
Couldn't say.
Do you have legal training?
No.
Real estate broker type training?
No.
Do you recall what contract you reviewed?
This would have been the contract between, Windermere Oaks Water Supply Corporation and Dana or Friendship or whatever it was. This would be the 2015 contract.
Do you distinguish between Dana Martin and Friendship Homes?
Check the form.
Objection form.
She's a person, so I know her as a person.
Do you distinguish between Dana Martin and Friendship Homes in your dealings with them?
Check the form.
Check form.
I don't know. I don't know how to answer that. I mean, I don't know how that would be distinguishing.
To the best of your knowledge, has anyone other than Dana Martin ever purported to do anything, take any action on behalf of Friendship?
I don't know that.
Do you know that Dana Martin has purported to take action on behalf of Friendship?
I don't know. I don't know that I don't know how she runs her business. I don't know what she's done in particular in what capacity.
You've dealt with her for how long on this? I'm not going to use the long term of this agreement. I'm going to call it the October 2019 agreement, the one you just did. You know what I'm talking about?
The October 19th agreement?
The October 2019 agreement.
October 2019 agreement. Okay, what about it?
You know what I'm talking about, right?
The October 26, 2019 agreement.
Right.
Okay.
You know, okay. Now, how long have you been dealing with Dana Martin to get from wherever you started to that agreement?
Objection form.
Same objection.
That's kind of a vague question. I mean, you could argue that I was from the minute that I was elected as a board president or on the board.
When did you first discuss with Dana Martin the idea of resolving the matters in dispute?
So I'm trying to come up with a time period.
That'd be good.
I guess my problem in coming up with that time period is that at one point we discussed in executive session, what to do about the matter. But
Did you have Dana with you?
No.
When did you talk with Dana Martin about it first? That's my question.
I mean, sometime within the last several months. I mean, I can't remember exactly, if it was August, if it was September. It had to, if it was July, it had to, as I recall, we were trying to find dates for our mediation. And so, I think we talked about dates for mediation. I don't know.
I'm sorry.
I can't even remember when our mediation was. It was, I guess it had to have been, was it September or early October? I can't remember exactly that.
Who came up with the idea that maybe we ought to mediate?
I can't remember who exactly came up with that idea.
Somebody on the board? Somebody with Dana Martin?
It may have been executive session.
Object form. I'm going to caution the witness to the extent that there was a legal strategy decision made or discussed in executive session or with counsel. I instruct you not to answer the question. If the question can be answered without incorporating legal strategy decisions on whether or not to mediate, as discussed with counsel, you may answer.
So I'm going to have to take advice, because I believe we discussed it in an executive session.
Okay. Look, I'm going to stop wrangling with you about this. You just don't answer and we'll move on, okay? Here's my question.
Okay.
Tell me the time when the topic of resolving this dispute first came up to the board.
Check
the time. If you don't want to answer it, I don't care. Just say you're not going to answer it. When in time did the topic of resolving this dispute come up with the board?
Object form.
I mean, I can't tell you when in time. I mean,
What were the
at some point this year. I mean,
what were the
but I can't tell you.
circumstances?
And I'm going to the extent that she's inquiring into the circumstances of a board's discussion as to legal strategy of whether or not to resolve pending litigation. Ms. Allen, are you really asking this question?
No, I'm not asking the question that you're phrasing. No, I'm not asking that at all. I'm thinking maybe if he can remember how it came up, he can remember when it happened.
You're asking
And
about
if he doesn't
when.
want to answer it, I don't care anymore. Just don't answer it and we'll move on. I just want my questions out there.
Mr. Gimenez, to the extent she's asking about when the board decided or discussed whether to resolve pending litigation, yes, I'm going to instruct you not to answer on the basis of the attorney work product and attorney-client privileges.
Okay, now I'm going to ask you the question that I'd like for you to answer. And if you don't want to answer it, just say so. We'll move on.
Okay.
Can you tell me a date when the topic of resolving this dispute, of taking steps to resolve this dispute, first came up.
I'm going to object to form, and particularly based on that objection, I'm going to instruct the witness not to answer to the extent that it inquires into privileged and confidential communications among the board regarding a pending legal matter.
I can't provide you with the time.
Can you help us to pinpoint a time by recalling the circumstances under which the topic came up?
I'm going to object to the form, and I'm going to again instruct the witness not to answer as to the timing or circumstances of any legal strategy matter made with respect to pending lawsuit. I'm instructing you not to answer.
I'm going to heed counsel.
Just say, I'm not going to answer that question.
I'm not going to answer that
Thank
question.
you. Now, when you were elected to be on the board, was it your view when you joined the board that there ought to be a settlement of the dispute?
Was it my personal view that there should be a settlement of the dispute?
Yes.
Depends on your definition of settlement. I mean, I wanted the dispute to be over.
How did you have a plan in mind of how you were going to, or how you would suggest or recommend that it be over?
No, ma'am.
You did not.
I'm not an attorney. I, wouldn't be able to come up with a strategy. I knew that I knew that the people who voted for me want resolution and an ending of this matter. And it was a 2-to-1 vote in favor of me, and almost a 2-to-1 vote in favor of myself and others, that we want the matter to be finished and over and done with, so that we stop paying all the legal fees, so that we can focus on the business of the corporation, which is needing substantial attention due to all the distractions that we've had with this litigation. And so I think that maybe gives you some, I think that answers the question, hopefully.
Well, what I'm hearing is that when you joined the board, you were of a mindset that the litigation needed to conclude so that it wouldn't cost money and be distracting, but you didn't really have a thought in mind of how it ought to conclude. Is that fair to say?
That's fair to say.
All right. When you joined the board, is it accurate that the board's view was to oppose these plaintiffs and their effort to recover the property?
Object to form. And to the extent she's asking about anything you've learned about the board's position in litigation since you joined the board, I'll instruct you not to answer. To the extent she's asking about any knowledge you have of the board's litigation position prior to you joining the board, you may answer.
So with that advice, I think that the knowledge that I had about the board's opposition to the plaintiffs was related to the Toma lawsuit. To oppose that for various reasons of whatever they were. I knew that.
Yeah, what were they?
In the Toma lawsuit?
And to the extent she's asking about information you have acquired about the board's position since you have become a director in executive session and discussion of ongoing litigation, I'll instruct you not to answer. To the extent she's asking you about what your understanding was of the board's action with regard to the Toma suit before you joined the board, you may answer.
Okay, so your question, ask your question one more time. We got that instruction.
She can read it back.
Okay.
Your question was, what were they? And
you your answer in the Toma lawsuit? And she said, yes, sir.
Okay, so, but back up a little bit further than that. Yeah, what were what?
I think I can kind of start over and get us back on the track. My understanding is that you were talking to us earlier about just information that you gleaned about the Toma lawsuit before you became a director. Did I hear you right?
Yes, ma'am.
And that there are reasons for why it was that the position taken in that lawsuit was to oppose or try to prevent the organization from recovering the property. Do you remember that discussion?
Between us? No. So.
Okay, well then, did you come to understand why it was that the board was in opposition to having the organization recover the property?
Objective form.
And objective form, and again, to the extent that the question inquires into matters of litigation position and strategy of the board prior to you coming on the board and your understanding then, you may answer it to the extent that it inquires into knowledge and information you've obtained as a board member in confidential and privileged communications. I'll instruct you not to answer. With that dividing line, you may answer if you can.
So I'm recalling 2018 and 2017, and there may have been a member communication to this effect or not, but there may have been, just discussions around the neighborhood that and I remember, it's coming back to me, some emails and things that were put out by Toma, where there was discussion about whether what the plaintiffs wanted in that lawsuit would cause additional litigation. Okay. And I believe Toma did not believe that would be the case, but there were others that I've heard that said, if Toma is successful, or if the board were to agree to Toma's claims, that there would be much more additional litigation that would cost the neighborhood and community and the corporation a lot more money to litigate.
What other?
And so that was my understanding of that lawsuit and its ramifications.
What other litigation could there have been? Did you have any understanding about that?
As I understood it, there would be a lot of additional contractual. If you break a contract, there could be contractual litigation. There might be litigation with the title company. Those were things that I heard. So it would be basically opening it up to a large number of additional pieces of litigation.
To your knowledge, were there ever any legal opinions of attorneys on the topic of whether there might be other litigation, and what would it be?
Objective form, and to the extent that counsel is inquiring as to legal opinions regarding ongoing litigation that you have learned of in the course and scope of your role as a board member, and particularly including executive session. That is attorney-client privileged information or product privileged information. I'll instruct you not to answer. To the extent that it inquires as to any such knowledge or information you acquired prior to you joining the board, you may answer.
So there was a letter from the previous counsel to the Water Corporation, a fellow named Zeppa, and I think that letter was provided to a number of people, and I believe that I recall receiving that letter. It was dated in 2015 or 16 or even 17. And I don't recall the exact date of the letter, but he was the attorney at that time in 15 and 16, I think. And so, I remember reading a letter from him, to maybe to that effect about the additional litigation, but My memory's foggy on the exact things related to your question. I recall some other things that were in that letter, but
So this was a letter that was from, if I understand you, from Zeppa to the board, and you got a copy of it at a time when you were not on the board. Is that right?
I think so.
Who else got a copy of it?
I'll tell you.
You mentioned earlier other people did. Do you remember that?
Other people?
Got a
Yes.
copy, yes, sir.
If I got it, other people got it, I would guess.
Who gave it to you?
That I can't remember. I'd have to look that up. If I could find that from years ago.
Okay. A member of the board, do you think?
I don't know. So there was a petition hearing at one point, a petition for removal, and I can't remember if that letter from the attorney, I don't know the exact date, right? I can't remember when that petition hearing was. I can't remember when the date of the letter was. It seems to me that it was in conjunction with that, but I could be mistaken.
Okay.
And the attorney letter basically said, everything had been, it talked about the transaction, et cetera, and the legalities of it.
So if memory serves, it does not always, what I think you're referring to as the petition hearing was the meeting at which it was considered to remove Dana Martin from the board, right?
Correct.
Memory serves, that was March 2017. Does that sound right?
I'll take your word for it.
You were not on the board.
No, ma'am.
Your best recollection, if I understand you, is the Zeppa letter that you're referring to is somewhere in that time frame?
Possibly. Possibly.
Okay.
But like I said, I don't want to be held to that because I just don't. I think it would have been around 17, but I'm not exactly sure.
Okay. To your knowledge, did Mr. De La Fuente or anybody else with the Lloyd Gosselin law firm ever write any kind of follow-up correspondence to Ms. Mitchell down there on behalf of Dana Martin and Friendship Homes to the effect that the January 25th letter was incorrect?
I don't know about their correspondence.
So you don't know of any such letter? In other words, did Mr. De La Fuente ever convey to Ms. Mitchell, so far as you know, or to Ms. Martin for that matter, that he was taking this back and the January 25th letter he just shouldn't have written?
I'm unaware of any correspondence between our attorneys and what they do. That's not normal course of business.
Well, how do you think this January 25th, 2019 letter got prepared?
Check the form.
Check form.
Don't you think the board authorized it?
Check the form.
I don't know.
Would it matter to you as a sitting director today to know whether or not the board authorized the January 25th, 2019 letter?
Check the form.
Check form.
Would it matter? I'm sorry, say the question. Would it matter? Would it matter?
Do you acknowledge that as a member of the board of directors, you have an ongoing duty to safeguard and protect the property and assets of the cooperative?
Check the form.
Check form.
Do I have a duty to protect the assets?
Do you understand that the board of directors is the group of people with the responsibility for the management of the affairs of the enterprise?
Yes.
And the well-being of the property and assets are part of those management responsibilities. Isn't that right?
Check the form.
Check form.
I'm not sure about that.
Well, if it's not the board's responsibility, whose responsibility is it?
Check the form.
Check form.
Yeah, I don't know. I think the allegation in the, I don't know. The allegation in the petition is that somebody other than the board has that right, but I don't know. I'm confused.
Okay, you're on the board, right? Mm-hmm. Are you confused about the responsibilities of the board with regard to the property and assets of the business?
Object form.
I'm not confused about that.
Whose responsibility is it to take care of the property and assets of the business?
Object form.
I don't know.
If it's not the board, then who are the candidates
Object form.
for that responsibility?
I don't
Object
know.
form.
Okay. Right before we took a break, we looked at what I believe is Exhibit 2, which is the transmittal of the Bolton Appraisal. Is that right?
Yes, ma'am.
And
Exhibit
we
2.
saw that the Bolton Appraisal went at the very same time to Bill Elshire and Mr. De La Fuente, correct?
Yes, ma'am.
Okay. Now, look at Exhibit 3, which is the Bolton Appraisal.
Gotcha.
And actually, I can tell from what you're holding that you have a copy that is missing some of the pages, and I'm going to swap you out, okay?
Okay.
So I'm going to give you this copy of the Bolton Appraisal so that it will be complete. Let me hand you that. That's Exhibit 3. I'm just going to take this one, and is that okay with you? Because you can see that it's a little thinner.
Yes, ma'am.
Okay, I want you to have a complete copy. And this is the appraisal that says that the property that was sold, in your words, to Martin or Friendship in 2016 was actually worth $700,000. Is that right?
Object form.
So I'm sorry, say the question again, please.
This is the appraisal that the board commissioned and that reflected that the property that was sold to Martin or Friendship in 2016 was actually worth $700,000, correct?
Object form.
There's a lot of, so I don't know, there's a lot of assumptions in that statement.
Okay. The Bolton Appraisal, you know without a doubt the Bolton Appraisal was paid for with money from the Windermere Oaks Water Supply Company, right?
Partially.
Well, how much money was paid out of the coffers of the Water Supply Company for that appraisal?
I don't know.
How much legal fees were paid in conjunction with the preparation of that appraisal out of the coffers of Windermere Oaks Water Supply Company?
I don't know.
But you know that that happened, don't you?
That the corporation paid for this and legal fees?
It paid legal fees for the preparation of Exhibit 1, right?
I presume so, yes.
Have you not reviewed the invoices to determine what it was paying fees for?
I have, but maybe not for that date.
Well,
I mean,
the invoices would certainly show us what was billed and what services were furnished, right?
yes.
Okay. You would certainly assume, unless you were told to the contrary, that the Water Supply Company paid good money in connection with the preparation of Exhibit 1, right?
Good money is your term.
How about any money?
It paid money.
How about any money? It paid money, right?
Paid money.
Does it have bad money?
Check
Money.
form.
I mean, seriously, does it have bad money?
Check
It paid
form.
money.
And when that appraisal came out, the board sent a letter around. You told me you read the letters. It's Exhibit 4 here to report that it had gotten the appraisal and was prepared to go forward, right?
Check form.
Yes, ma'am, I did read this letter.
Okay, so you recognize Exhibit 4 as a letter that came from the board in conjunction with the Bolton Appraisal, right?
Yes, ma'am, I read this in December when I received it.
And it talks about there going to be a public meeting on January the 12th. Do you see that?
Yes, ma'am.
Did you go to that meeting?
No.
Let me show you Exhibit 5, which are minutes I got off the website of the water supply company for that meeting.
Okay. Okay.
And those minutes reflect that after the discussion at that meeting, the board was inclined to move forward to pursue recovery, correct?
I think that's what this says, possibly. Yes, ma'am.
Okay. The board did not do that, did it?
Check the form.
The board did not ever move forward to pursue the recovery of the property or the difference between what was paid and its value. Isn't that correct?
Check the form.
Section 4.
I think that's incorrect.
Tell me when the board moved forward to either recover the property or to recover the difference between what was paid for it and its actual value.
Objection form.
Check the form.
I don't know. I don't know. I'm having a hard time with your word "actual value."
What word would you want to use to answer that question?
Check the form.
What word would you like to use so that I can get an answer to that question?
Check the form.
The board has been engaged throughout 2019 in seeking an end to litigation.
Okay, well, that's not what you told me a little while ago when I asked you, when was it that the topic came up of resolving this dispute?
Check the form.
When did the topic come up?
Okay, when did those ongoing discussions that you just referred to begin?
Oh, I see the problem here. I'm juxtaposing the board and me personally. I think what I had said earlier was something about me wanting to end the litigation. That was my personal opinion.
Then let me be
And then
clear.
I think you're asking about the board.
Let me be clear. With the board, with the group of people with responsibility to manage the affairs of the business, with that group of people, when did the topic come up of resolving this dispute?
And object to form. And to the extent that this inquires about privileged communications among the board regarding litigation strategy and action, I'll instruct the witness not to answer. To the extent that this inquires into public statements of the board regarding the board's actions or decisions, those of course are not privileged and you may answer.
Okay, so when did the board, I'm sorry, go ahead, I've got that counsel. Ask again, when did the board, when did the group of people?
I want to know when the topic came up in 2019 that you just talked about, those ongoing discussions. Remember that?
Okay.
Okay, when did those begin? Those ongoing discussions about resolving this dispute.
And I'm going to instruct, to the extent that there was discussion of the board of legal strategy to resolve pending litigation, to the extent that those discussions were not public, they were privileged, and I instruct the witness not to answer. To the extent there are any public discussions aboard about its decision to move forward with a path to end litigation, the witness may answer.
So you're asking when did it begin? I think that beginning in, I mean, our first meeting in March or possibly April, we began having executive session discussions that are on our agendas about the litigation. So that would have been, I mean, I'm trying to recall when, and the answer, I guess, is either in late March when we had, I remember that we had our first, so it was March 9th, and I think that we possibly had a meeting on either March 20th or March 29th. I can't recall the exact dates. But at that time, or at a board meeting in April, we had that on our agenda. So sometime in that time frame, we were discussing these issues.
Okay. Was there ever a time, whether you were on the board or off the board, was there ever a time that you know of when the board communicated with Ms. Martin or Friendship or lawyers for them or other representatives of them any demand that they either return the property or pay the difference between what they paid and what Bolton said the property was worth?
Object.
Object form.
That's a really broad question. And ask me to speak about things that I wouldn't have knowledge of. So no.
I'm really not asking you to opine or testify about things that you don't know, okay? But I can't tell what you do and you don't know until I ask. Do you understand that?
I understand.
And so maybe we can just break it down by time. Let's just start when you have been on the board. While you have been on the board, has the board ever made a demand on Martin, Friendship, or somebody acting for them to either return the property or pay the difference between what was paid at the time of closing and what Bolton says it was worth?
No, because nobody has, no.
So that has not happened while you've been on the board.
Not to my recollection.
To the best of your knowledge, did it ever happen before you got on the board?
Object form.
I can't speculate.
I'm not asking you to speculate. That's why I prefaced it with to the best of your knowledge.
The only evidence I would have would be this letter, Exhibit 1, as to what happened before I was on the board.
So,
To the best of my knowledge.
is it fair to say that the closest thing you know of to the type of demand that I'm asking about is Exhibit 1?
Yes.
Let me show you Exhibit 10, which I think is another of the board's letters to members, which you said you read. And I'm sorry about the highlighting. I happened to get away with nothing but one copy.
Okay. Okay.
Do you recognize that as one of the board's letters to members?
Yes, ma'am.
What is its date?
Object form. Are you asking him to read the entire letter?
I asked him, what is the date?
Oh, I thought you said, what does it state? I'm sorry.
What is the date? I don't have a copy. What is the date?
July 10th, 2019.
Okay. So that's this past summer.
Yes, ma'am.
You're on the board.
Yes, ma'am.
And what does the board say to the members about the result in the Toma lawsuit?
Object form.
Would you like for me to read it to you?
You can if you need to, but you were on the board that wrote it.
It says
Check form.
Fourth, in mid-June, an appellate court ruled in favor of WOWSC and sided with the lower trial court's judgment rendered last year with regards to the land sale by WOWSC in 2016 and related agenda items. In some,
I'm sorry,
and related agenda items.
Okay.
I'm sorry. In sum, while the previous board did not properly post parts of the agenda items related to the land sale, the violation did not warrant the court's intervention in voiding the land sale. This is a victory for WOWSC because voiding the land sale would have had serious financial implications for WOWSC. That's the paragraph.
All right. You were a member of the board that promulgated that letter, correct?
Yes, ma'am.
Did you write it?
Not in its entirety.
What part of it did you write? Did you write any part of it having to do with the Toma lawsuit?
I probably did, but this was reviewed by counsel, and there were a lot of...
I didn't ask you what your lawyer did or said.
Okay.
I asked you what you did or said.
Okay. Well, I wrote... Yes, I wrote that, and it was revised by counsel.
You do hear me that I'm not asking you what your counsel did or said, right?
And Mr. Gimenez, just offer what you particularly drafted, and if the letter does not represent what you drafted, then just tell Ms. Allen that.
All right, okay.
So I can't...
I'll bite. Are you going to tell me that letter does not represent what you wrote? It's not what you wrote?
I mean, what draft? I mean, I can't tell you what...
You're holding a letter that went out to the members of this water supply company.
Yes, ma'am.
You are a director responsible for that letter, right?
Yes, ma'am.
You wrote part of it, correct?
Yes, ma'am.
Does what you're holding in your hand accurately reflect what you wrote about the Toma lawsuit?
An objective form, and Ms. Allen, he's indicated, not to anyone's surprise, that the letter was written with the assistance of counsel. So the extent you're trying to get behind what the attorneys might have advised the board in making representations about an ongoing legal matter, much to no one's surprise, I'm going to notify you that that communication is privileged, that advice is privileged, and I'll instruct the witness not to answer. Now, because you're asking about a letter which was drafted with the assistance of counsel, I believe you can see the difficulty with your question.
No, I can't. I have made clear 5 times that I am not asking him about anything that lawyers said or did.
And he has answered to you that he wrote that with the assistance and editing of counsel. So for you to ask what the nature of what he wrote is necessarily discusses what counsel advised him.
Just advise him not to answer, and we will move on.
I will advise him to answer to the extent that he can answer without revealing the advice of counsel in drafting a discussion of ongoing litigation.
So I wrote this letter with the advice of counsel. I can't tell you what exact parts of it were that I edited or changed or what have you.
What were the financial consequences to which you referred? Did I use the right phrase?
I'll read the sentence. This is a victory for WOWSC because voiding the land sale would have had serious financial implications for WOWSC.
Financial implications is the phrase. Forgive me.
Is that correct? Is that what you're asking about?
What were the financial implications to which you referred?
Litigation.
What litigation?
We discussed it earlier. It was litigation that would result from additional legal entanglements because of voiding the land sale. I think that's the context.
What information did you have at hand upon which you based your statement there would be financial implications?
Checked form.
I don't know. I don't know what I had on hand.
You wrote that for the purpose of persuading the members that fighting the Toma lawsuit was the right thing to do, didn't you?
Checked form.
No.
The word you used is victory. Isn't that right?
Victory, yes.
That it was a victory that the organization did not get its property back,
Checked
correct?
the form.
Objection form. Check form.
That's not correct.
What was the victory?
Checked form.
Voiding the land sale would have had serious financial implications for WWC.
And what I want to know is when you made that statement to the members, what information, if any, did you have suggesting that the statement was true?
Checked form.
Well, I can't answer that because that's privileged information.
Did you rely in making this statement on an opinion of an attorney?
I think I just said a few minutes ago that the attorneys assisted with drafting this letter. I can't tell you exactly what part of the letter I drafted versus what they added, deleted, changed. I'm sorry, I can't.
Okay, so you're not able to tell us here today that you relied on an attorney's opinion in making the statement to the members that there would have been financial implications
Object form.
associated with the return of the property. Is that correct?
Object form.
Object form.
You know, that's a very complicated question. I don't know
We're going to
how
break it
respond.
down because we're going to get an answer or we're going to find out you're not going to answer
Okay.
it. So how do we need to break it down? What's complicated to you?
Try it again.
Let's see it. All right. Step one. You made a statement in the letter to the members that there would be, what did you call it? Serious financial implications?
Yes, ma'am.
Serious financial implications if the organization were to recover its property, correct?
Checked form.
No, that's not what it said.
Well, what are you talking about then?
Checked form.
Voiding the land sale.
And what does that mean to you? What would the result of that have been?
Checked form.
I'm not an attorney, so I wouldn't know exactly what that would have entailed.
You don't know what the plaintiffs were after in the Toma lawsuit?
Checked form.
They wanted to void the sale.
And wouldn't you think that would mean the property would come back to the organization?
Checked form.
I'm not an attorney.
You're on the board of directors, you're writing about litigation that's ongoing, and you don't know what the plaintiffs in that lawsuit are seeking?
Checked form.
Objection form.
Is that what you're telling me?
Checked form.
I don't know.
So you didn't have a clue what voiding the land sale meant when you wrote the part of that July 2019 letter. Is that correct?
Checked form.
Objection form.
No, ma'am. Yeah, that's the question again. I'm sorry.
Did you have any idea what the result of voiding the land sale would be when you wrote the letter that we see as, could you remind me the exhibit number?
10.
Exhibit 10.
Okay, I just don't know how to answer.
Well, it's an either yes you did or no you didn't.
Okay, so give me the question one more time.
Did you know what voiding the land sale would result in when you wrote the letter that is Exhibit 10? That's the word you used, right? Voiding the land sale?
It would have resulted in serious financial implications.
Did you have an understanding about what that would accomplish with regard to the property. What voiding the land sale would result in with regard to the property.
I think I said earlier that it would involve a lot of additional legal entanglements
Okay.
and litigation.
Did you have an understanding as to whether voiding the land sale would return the property to the organization?
I'm not an attorney, so I can't answer that.
If you had no understanding, that's a perfectly fine answer if it's honest.
Check the form.
Is it honest?
I don't know about any process. I don't know about the processes. So yes, it's honest.
Okay.
I don't know how those processes work. So
Did you know what the consequences of voiding the land sale would be relative to the right of refusal that was given?
I don't know that. I didn't know how that would work out.
Do you know it today?
No, I don't.
So even today, you don't know what the result vis-a-vis the property and the transaction would be if it were voided? Is that right?
Check the form.
I'm not an attorney.
So you don't know?
I don't know.
Okay. What happened, if you know, in between January 2019, when the board is making demand letters to Dana Martin and Friendship Homes, and July 2019, when it's saying that it's a victory because the land sale wasn't voided? What happened, if anything, to cause that change?
Objective form.
Objection form.
And to the extent that broad question inquires into the consideration or state of mind of the board in evaluating its position in litigation and in an ongoing dispute, I'll instruct the witness not to answer. To the extent that this question asks about something outside of those privileged communications and considerations, to the extent you can answer the question, you may answer.
Okay. Can you say the question one more time? Or?
We saw Exhibit 1,
Okay.
January 25th, 2019, from this lawyer that's sitting over here by you today, representing you, that talked about the unfairness of the transaction. I mean, you can read it again if you want to. Fraudulent hint and appraisal, stuff like that. Do you remember that? Okay. And made demand on Dana Martin and Friendship Homes and said, we're going to pursue litigation if you don't. Do you remember that? In July of 2019, the board put out a communique to the members declaring it a victory that the land sale wasn't voided. Did you remember that? Do you appreciate that those are two different positions?
Objection form.
Very
Check form.
different positions.
Check the form.
Objection form.
No.
You don't appreciate that. Do you think they're the same position?
Check the form.
Objection form.
No, they're different.
Okay, I thought that's what I just asked you. So you do appreciate those are different positions,
Check the form.
yes?
Form.
Same objection.
I don't know. I don't understand.
You don't know whether they're different positions?
Object to form.
Objection form.
You are asking about finite periods of time when there are things that happen in a continuum. So I don't know. I can't answer the questions that you're asking because of how it occurred differently.
So you don't know whether the position stated in the January 25th, 2019 letter and the position stated in the communique of July 2019 are different positions. Is that what you're telling me?
Check the form.
Form.
I just don't know on a legal basis how that works. I'm not an attorney.
You're on the board of directors that has to make decisions concerning the assets of this enterprise, right?
Yeah, I don't know that.
If I've gotten that wrong, then we have wasted a lot of time here today. I thought you were on the board.
I am on the board.
And I thought you agreed with me earlier that the board is the group responsible for managing the assets and the property of this business.
It's responsible for managing the business, yes.
And wouldn't it be prudent, reasonable, and diligent for a member of the board to educate himself sufficiently to know what position the board is taking with regard to its property at any given point in time?
Object.
Check the form.
Objection form.
I don't know about that. You're
Do
asking.
you disagree with me?
Well, you're
Just
asking
form.
certain questions about that have different legal connotations, and because I'm not an attorney, I can't answer those.
So can you tell me this? Did anything that you consider of significance, that is something that might be position altering for the board, happen between the January 25th demand letter and the July communique that we just looked at as Exhibit 10?
Object form, and to the extent that this inquires as to matters considered by the board in determining its legal position and litigation actions and strategies, that inquires into privileged matters, and I'll instruct you not to answer. To the extent this inquires about some external fact that you might know outside of that context, perhaps you can answer.
Okay.
Did the board learn facts that suggested to the board that it needed not to make a demand on Martin, but to celebrate as a victory the appellate decision in Toma?
Object to form, and I'm going to instruct the witness not to answer because it's literally asking what the board learned in making its litigation position decisions. And Ms. Allen, are you really going to keep asking these questions?
If you think for a second that I agree with you that the members of this cooperative don't have a right to know what information their governing body had when it was making decisions, then you and I have a serious difference of opinion.
Okay, we have a very serious difference of opinion
yes,
because
I do.
This entity does have attorney-client privilege. I'm pretty sure I've got some pretty good law on that.
I'm pretty sure you don't get to cloak everything that is done with the board in secrecy. And if it doesn't want to reveal the facts that it had now, that's fine. I don't want to hear them later.
If you want to ask why this board made certain decisions with respect to an ongoing suit brought by your clients, I'd suggest that's about as improper a purpose for a deposition as you can take, but you're entitled to ask whatever questions you want, and I'll issue the objections, and,
Right.
and you know we will.
Let's move. Are you done?
Keep asking your questions.
Okay, I think he instructed you not to answer.
Yes, ma'am.
You just need to say, I'm going to follow his instruction and I'm not going to answer.
I'm going to take his instruction. I'm not going to answer.
Okay. And again, just for my record, are you taking his instruction and not answering on the basis of a claim of privilege?
Yes, ma'am.
Okay. In other words, it's not because you don't know it, it's because it's privilege.
Object to form.
No, ma'am. I mean, I don't know it, and it's privileged. I think
How
you're
could
asking.
that be? You either know it and it's privileged, or you don't know.
Object to form.
I don't know what I'm answering.
It's really simple.
Okay. Ask it again.
You know what the position is in the January demand letter. January 2019, demand on Dana Martin and Friendship Homes for all the wrongful conducts that's described in that letter. You know that, right?
Object form.
Object to form.
Do you read it differently? If you do, just tell me that.
Object to form.
Object form.
I don't know how you want me to read it.
How you read it, that's how I want you to read it.
Object to form.
So what I'm reading is that this is a demand to preserve documents, correspondence, records, and communications, including emails, text messages, and phone records that you have had with Mr. Hinton or with any past or current member of the WOWSC board regarding the property, the Hinton appraisal of the transactions.
Slow down.
I'm sorry. And two, to meet and confer promptly with WOWSC through its legal counsel to discuss WOWSC's claims against Ms. Martin and Friendship Homes and a proper resolution thereof.
And so what does the next to last sentence of the letter say, since you can read it?
The next to last sentence.
I'm not talking about the one that says, "We look forward to your prompt." The one above that. What does that say?
I'm sorry, I'm trying to find it.
It starts, "In the event that."
In the event that you fail to do so, WOWSC will have no choice but to pursue all available avenues of relief, including pursuing litigation against Ms. Martin and Friendship Homes. Okay.
Okay?
I'm sorry, so what's the question?
So this is a letter that threatens to pursue litigation against Martin and Friendship, right? Exhibit 1. You're not, I mean, it's,
Yeah, it says that.
Yeah,
Including,
okay.
including. It says including.
now, at some point or another, the board decided not to pursue litigation against Martin and Friendship. Obviously, it never did that, right?
I guess it depends on your definition of litigation.
Okay, I'm ready. Just tell me when, in any context, you believe that the board caused the water supply company to pursue claims against Dana Martin or Friendship Homes. Any context.
Check the form.
Well, it says including litigation, so that means that there are other avenues, and it says other avenues.
Do you understand my question? Because I'm thinking that you might not.
I've had a hard time all day with that, I'm sorry.
Okay. Is there any context that you're aware of? You had a hard time with the word litigation, so I'm just going to broaden it. Is there
Okay.
any context in which you're aware of that the board that you sit on has caused the water supply company to pursue claims against Dana Martin or Friendship Homes in connection with its acquisition of property?
We had an open meeting about that on October 26th, and we discussed very openly about all of the different claims, and we discussed the mediated settlement, or the mediated agreement, I guess, with Ms. Martin. And so in that context, we did other things than pursuing litigation.
In that context, what were the claims that the water supply company had against Martin or Friendship
Check the form.
that were articulated or discussed?
Check the form.
We had an entire term sheet that we sent to our membership about what those were.
Do you understand what I'm asking when I ask you about claims?
Apparently not.
Allegations of wrongful conduct. That's what I mean. Do you understand that?
Okay, now I do.
Okay. So, in the context you're describing of the October 26th meeting and discussion, was there any discussion of claims that the water supply company had or intended to assert against Martin or Friendship Homes? I don't recall us talking about those claims, but you know, my memory is not perfect. It's possible that we
mentioned it. I mean, I don't have a videotape of it to review that. I know somebody does, but it's possible. It's possible that it was discussed, but I can't recall specifically in a 4-hour meeting, 4.5-hour meeting, if that was discussed or not.
Does it come to mind any claims that the water supply company has or might assert against Dana Martin or Friendship Homes?
Checked form.
Does what?
Can you think of any?
Checked form.
Can I think of any claims that the
Water supply company has or might assert against Dana Martin or Friendship Homes?
Checked form.
I'm not an attorney, so I don't know.
Except in the context of the January 2019 letter, has there ever been an occasion where the board has discussed pursuing claims against Dana Martin or Friendship Homes and authorized that action?
Object to form, and I'm going to object to the extent that it asks about discussions of the board about whether or not to take a particular legal action in executive session and what it considered in the course of that. To the extent that this inquires about actual action, the last part of the question inquires about action taken by the board in open meeting, you may answer that question.
I don't recall any open meeting where we would have discussed that in 2019. And we don't do so under the advice of counsel not to discuss pending litigation in open meeting.
You do understand that if the board were to authorize claims to be made against Dana Martin and Friendship Homes, it would need to do that in an open meeting properly noticed, right?
Check form.
If it were to pursue claims,
If it were to authorize the pursuit of those claims, correct?
so you're talking about like after executive session, if we were to come out and authorize that.
That's how most people do it.
Yeah. So am I aware that that would be the process? Yes, I'm aware that that would be the process.
Did it ever happen?
No, ma'am, it has not happened this year.
Did it ever happen to your knowledge at any board meeting that you attended or are aware of?
I just said no.
I thought you confined your question to your time on the board. That's why I asked the follow-up.
Okay. So,
I'm talking about any
okay,
time,
I'm
ever.
sorry. So ask the question again.
So I've heard you say during your time on the board that the board never authorized the pursuit of any claims against Martin or Friendship, correct?
Right.
Closest it got was the January 2019 letter, right?
Right.
Then, before you got on the board, are you aware of any occasion where the board authorized the pursuit of any claims against Martin or Friendship?
Check form.
Or Hinton, for that matter?
Check form.
I'm not aware of it. I'm not aware of any, but I'm not aware of any.
Has there ever been an occasion where Martin or Friendship has advised the board that Martin and Friendship have claims they intend to assert?
No, ma'am, I've never received any kind of, or the board has not received that.
Are you aware of any claims that Martin or Friendship have they might assert against the water supply company?
Check form.
I'm not an attorney, so I can't speculate on that.
To the best, so are you telling me you're not aware of any?
Check form.
I'm not aware of any.
Okay.
It's about one, Cappy. What do you think about a lunch break? Or how much do you have? Maybe the predicate to that is what else you think you got. And
I really thought I'd have been done by now. I'd like to go a little bit longer.
okay.
But I'm going to ask the court reporter. Want to go off the record for a second?
Off the record. We are off the record at 1:01.